Okay, I think we're ready. That's a minute and a half. We've given everybody a good enough opportunity. So I'm not certain who all's here, but I want to welcome you to our first of our SBIR training that is specifically geared towards our Small Business Development Center advisors. So as some would call it, the train the trainer, so to speak. What we want to do is try to spend a little better focus instead of the basics, this way I've talked to Laurie about this, and more of the practicality of the challenges that a SBDC advisor comes up upon with a innovator or with a client. And so we are very excited to be able to introduce Laurie Moncrieff, the Executive Director for Reset. And she has agreed to pull in several experts from across a variety of fields for us over the next few weeks. So those of you that have been on our Lunch and Learns and are jumping in on this, welcome. And those of you that haven't been anywhere but now are joining in as an SBDC advisor, we want to welcome you. Today is intellectual property, and Laurie has invited a special guest to speak to us from the legal point of view. And so with that, and I also have Jessica Torres, who is with the Wichita State University's PTRC, and Laurie has that in the slide deck. She will give you, or we will have a one-page document after this. The PowerPoint will be shared with you after the completion of today. So if you feel like you need to take notes, take extra notes, but you don't have to write down what you see. With that in mind, Laurie, hold on. I need to take care of, so Mindy, how are we covering the questions? If they have questions, hit the Q&A.
Yeah, so if you have any questions throughout this presentation, you should have access to a Q&A section at the bottom of your screen. So just put your questions in there and we will try to answer them live or type out the answer and respond to you personally.
And so I will encourage you, if you have questions, please write them down or get ready to ask the questions, because I've told Laurie I expect to see several of you speaking up with questions, those that have clients that you're working with or situations that you've seen in the past. So please be ready with your questions. With that in mind, Laurie, thank you so much for agreeing to work with us today. I'm going to turn it over to you and I'll turn the slides for you.
Thank you very much. Appreciate the invitation. So RESET stands for Restructuring Society through Education and Technology. And I'm pulling together a private-public partnership to focus on advanced manufacturing technology, workforce development issues. And John Moran is joining me, who is with the law firm Holland & Knight. And John, if you would just introduce yourself and your expertise, and then tell them just a little bit about Holland & Knight, if you would.
All right. Well, my expertise is in the intellectual property area, patents, trademarks, copyrights, trade secrets, generally, and as well as with respect to government contracting. My experience is dealing with small clients, large clients. I also do a lot of patent litigation, trademark litigation for a variety of individuals as well as corporations. With respect to Holland & Knight, Holland & Knight has offices throughout the United States, including other countries in Colombia and Mexico. It's a general firm with multi-specialties, one of them being the intellectual property that we have today. And in the age of the virus, we are even more of an individual firm, given that everything now is online and we can speak to and work with each other in multi-offices, just as this platform is taking place today. So that's a quick thumbnail sketch of just my background and Holland & Knight as a law firm.
I really appreciate you joining us today, John. So with that, Alan, if you would proceed to the first slide. So intellectual property overall, in a lot of instances, is a company's most valuable asset. And for that reason, it's really important to understand all the ins and outs and actually what intellectual property is all about. Because a lot of times people think of intellectual property just as patents, but it's much, much more than that. Next slide. So IP covers trademark, which is your brand, copyright, which protects artistic works, but as you'll see when we go on, it covers more than that. Domain name, which is your web address, your business name or your entity name, and then of course we get into the complicated area of patents. So trademark is kind of interesting if you think about it, and I actually learned about this a couple years ago, and it surprised me because I didn't know it. But protecting your trademark is really, really important. And a perfect example would be the company that used to exist by the name of Zipper. There was actually a company, and they invented the zipper, and they lost their rights to hold that trademark because they refused or neglected to protect that. And it became a common noun, if you will, the zipper. And that same thing applies for escalator and yo-yo, actually. That they started out as that was their invention and that was their product. But over time, as people were allowed to refer to those items as a zipper or an escalator, they basically lost the rights to have that as their own product, if you will. And Kleenex is a perfect example. We use the term Kleenex all the time, but the reality is that Kleenex bends over backwards to constantly refer to it as facial tissue, because they are policing their trademark and working very, very hard that Kleenex doesn't turn into Kleenex, that there will always be competitors, that they can distinguish their product as Kleenex from the other facial tissues. So if you think trademark isn't important, I mean, for Kleenex to lose that brand altogether would be devastating in this instance. That's an example of how important those trademarks can truly be. So copyrights. Copyrights are typically around artistic works, novel, poems, photos, movies. But you actually, as a business, can copyright different business applications. And I know a lot of times that folks, when they do a PowerPoint or do a presentation, they'll put copyright on the bottom. And John, I actually want to ask you that question, if I could. If you write copyright on a PowerPoint, is that legally protected as a business owner?
The answer is yes, for at least two reasons. First of all, the copyright protection exists automatically once something is reduced to writing, for example, or in the case of a PowerPoint. So the copyright exists at that point in time and is enforceable. The notice that you referred to should be, you know, the little circle with the copyright, the year that you're presenting it, and then in addition to those, the person or entity that claims the copyright in that particular work. So to answer your question is, yes, it can be protected. The notice is useful, but is not technically necessary. It should be used just to let everybody know that you're protecting. If you don't, then you're going to run into, you know, a lot of different problems. So it's a very simple thing to put on there, just a symbol, the year, and the entity that's claiming the copyright protection.
So your advice to a small business would be, if you want to publish something and keep credit for it and hold it as your own, would be to do that, put the symbol, the year, and your name.
Absolutely, yes. Little things like that help. It identifies, it tells your competitors and everyone else that you're asserting your rights and you're putting them on notice that there is copyrighted material in whatever it is you're putting notice on.
So
Now,
question,
go ahead.
I was going to say, John, so question with that then, if you have created something, but you've not put the C on there and you've not put the date on there, but you've been using it and you want to stake your claim to it, do you then put the C on it and date? Do you put the date it was first in use?
The answer is yes, you should put it first in use. Many people don't, but the preferred practice is put the copyright, the date you're asserting it, and the owner of the entity that is claiming copyright protection. So you should do those things. As a matter of course, simply as writing your name on something when you sign it, it's something very simple to do and should be done as a matter of course in everything that a small business does. Obviously not invoices, but anything of creative or that goes to the heart of their business. And we'll discuss later on other types of notices in other contexts, but putting notice should be as a matter of course.
So another IP area, and this may seem like a really simple thing to people, but I'm going to give a couple of examples on where it's really important to pay attention to your domain name. So a domain name is, of course, your internet address. And to me, it adds credibility to your business. It shows that you're forward thinking when you have a really creative domain name. It allows you to move from one internet provider to the next, and it builds the brand. But there are some things with domain names that I know some small businesses that I've helped that experienced where they hired somebody to create a website, and that website creator went ahead and created the domain name for that business. And the business never retained the password and the information on where that domain name was created. So at a point down the road, they then wanted to change internet hosters, went to change the name, and could not prove that it was their website. And what could have happened, it ended up all good. They ended up tracing it to who originally hosted it. The company that created the website had changed names. So they found a person that was a common thread for the old website company that created it, the new website company, and then they traced it down to that internet provider and got all the passwords and everything they needed. But what could have happened is that small business could have spent all the time and effort to be known at that website address, and then somebody could have essentially taken over their website, and or I've heard instances of people charging to give you your information for your domain and website address. So like just a cautionary thing, if you create a domain name or you have somebody go in and create a domain name for you, to understand that it's important for you to retain the rights, that that's your domain name and you have the passwords and can prove that you created that domain name. John, is there anything you would
Laurie?
add? Yeah.
Yes. I'd like to, in the context of a domain name, obviously is associated with your small business web page. And in developing a web page and any contracts you enter into with developers, you ought to make sure that the content belongs to you, that the content was developed as a work for hire, which under copyright law then puts ownership of that content in the company, rather than otherwise without that it would be the developer's content and they would own it. So it's extremely important to make sure that the contract you have with the developer gives the company ownership and does so, for example, by saying that the content is a work for hire, which is magic legal words, which puts ownership in the company. In addition, going back to notice, you should also put on the website copyright notices. And it could be on multiple pages. It doesn't need to be just on the home page, but you should also put copyright notice, just as we discussed with respect to printed material or PowerPoints. It should also be on the web page. So sorry for the interruption, but I just wanted to add that because it was appropriate this time.
No, that's great, John. I appreciate you jumping in. So business entity name, you know, why is that important? Again, use on business documents, advertising, marketing, business formation documents when you go ahead and set up your company, loans, domain names, and again, a little bit redundant, but business registration. And a lot of times you can run into an instance when you come up with a company name, you should do an extensive search to make sure in advance of claiming that as your business entity name, that there isn't another company that does the same in the same line of work that could make a claim that you essentially can't have that business name. Really important to do that. So patents. Patents are the best protection for new product. You can only get a patent if it's a concrete idea, formula, or product. You cannot have a patent if there's an existing patent out there on that same product. And as John had talked about earlier, in this instance, if it's already been printed in publication, and it has to have a useful purpose. And that's a very simplified explanation of what can have a patent and what can't. But just to go over the basics, is there anything you want to add to that, John?
Yes, there's one. Well, I'm not sure what the next slide has. Are you going to different types of patents?
Yes.
Okay, I'll wait till there. Yeah.
Okay. All right. Go ahead, Alan. So 3 basic different types of patents. There's a utility patent, the design patent, and the plant patent. And John, why don't you go into detail on this slide?
Okay, fine. Yes. Well, I'll start with the easiest one, plant patent. That's very descriptive. It's a plant as of various types of plants. For example, corn, soybeans, farm materials, as well as roses, all types of plants. Design patents are just that. They're similar to copyrights in the sense that a design patent only protects the shape of an object or a product. Utility patent is what everybody considers to be a patent. We're normally talking about a patent is the patent on radio transmission or a new light bulb, for example. Design. What I wanted to say before was also the little asterisk at the bottom is a provisional patent. That's for a small business. And the reason is, first of all, the other types of patents, specifically the utility patent, is very expensive to obtain. A provisional patent is relatively inexpensive. And what it does is gives a small business an ability to mark their product, that if there is a patent pending, put other competitors on a notice that they ought not to or tread very carefully in that area. But what it also does is gives a small business some financial credibility, and it can be used as collateral for obtaining loans. When you go try to loan, they say, well, what do you have, what's your intellectual property? What do you have protection? Then the provisional patent gives the small business credibility, and it also gives the lender then some protections that there is a legitimate idea here that's being attempted to be protected. Now, what is a provisional patent? It is the precursor to utility patent. And basically, in very simple terms, it's everything about your idea, written and all of the what ifs that you can think about for your idea written down in some form. It could be a jumble, or it could be a nice long paper, for example, but all written down and then filed at the patent office. Once that is done, the entity then can put patent pending and has the resulting impact, for loans, collateral, and competitors. And it also gives the entity 1 year within which to decide whether or not to invest into a utility patent. During that year, the actual provisional patent is secret, so that if after the end of the year they decide not to get a patent or file for utility patent, the contents of that provisional patent remain secret. So there are lots of side benefits, both legal and financial, to a provisional patent as it dovetails with a utility patent. Now, there are no provisional patents for design or plant patents in either case, but it is useful for a utility patent.
And if I'm not mistaken, John, and correct me if I'm wrong, the other patents, utility, design, plant, are for 20 years. Is that correct?
Utility is. The others have different. For example, the design patent is for 17 years, I believe. So it's the 20 years that you mentioned is not from when the patent issues. It's from when it's filed. Now, there are provisions within the patent office that do not penalize the patent applicant for the bureaucratic delays within the office. So once a patent is issued, if it had been pending for more than 3 years, there will be certain extensions to the normal 20-year term. But the 20-year term is measured from application date, and the policy is that it's expected to be about a 3-year tendency, and thus the actual protection period is nominally 17. But that's just generally. But the answer to the question is yes, 20 and 17, or 14, I should say, for design patents. I'm not sure off the top of my head with plant patents, but I could find that out if there's interest in that particular subject matter.
And in some instances, John, folks will get both a utility and a design. They can hold multiple patents for a product. Is that correct?
That's certainly correct. Yes. I mean, for example, you can have a new automobile wheel that can have a very specific structure or composition that would be directed to the utility patent area. And then that wheel could have a certain shape, which is ornamental, which will be directed to design patent area. And simultaneously could be copyrighted. So, the same product can have at least 3 different types of protection.
Okay.
It does look like we do have one question. I guess we have a couple questions. The first question is, how strong is the government contractor's protection of their IP by using assertions rights in government contracts?
I can answer live, I guess. The answer is, I'm not sure what you mean by how strong. It exists, let's put it that way. Now, in theory, some government agencies can trample on them, but in the ideal world, the assertion of rights in government contracts is an absolute essential part of protecting the IP. First, you have the IP, which is part of this discussion. But once you have it, asserting it and identifying it is very important. And once that's done, then in theory, the protection exists. Whether or not somebody's going to ignore that protection, I can't really say, but generally it is not ignored.
Thank you. And we do have one more question. It says, our utility patent took over 6.5 years to be issued. Although we were given some extension on our patent's life, can we do anything to request additional extensions?
The answer is you can petition, well, depending upon how long ago that took place. You should look at how the extension was calculated. The Patent Office gives very specific time periods. Now, and I use that as an example. For example, you say it took 6.5 years to be issued. The extension is only for internal U.S. Patent and Trademark Office processing time. Now, as an example, what would not be included in that would be if there was a continuation application filed or extensions of time were filed. They typically wouldn't be included because they are not due to internal U.S. Patent and Trademark Office delays. They are delays based on the applicant's actions. So to answer your question, is first thing you would do is check to see how it was calculated, and typically you can get that at the U.S. Patent and Trademark Office website for your patent. Next thing is to identify, the delays or the time periods during the pendency that were due to actions on the behalf of the prosecuting attorney or yourself, and then see if those two add up to the 6.5 years. If not, then you can ask the Patent Office to, depending upon how long ago it was, to reevaluate your extension period.
Thank you. And we do have, did you have something, Laurie or Jessica?
If possible, if I could add to that question a bit. And John, you were right on it with everything. I would have said it very similar. But the USPTO office, they do have like a call center help desk kind of that you can contact. And we aren't lawyers, so we can't give, the PTRC is not lawyers, so we can't give the legal advice aspects to those questions. But in regards to your specific question, that is something that you could call the help desk with and ask them. And they can give you a little bit more information in terms of if you would be able to do an extension or not. And then going back a little bit to John talking about how long each of those patents are, design is 15 years, and then plant and utility are 20 years. So it gives you a better clarification.
Yeah, and I'll also add to that the idea, that was an excellent idea of using the call center. Based on experience, the call center is almost always very helpful. It's an excellent resource, and thank you for bringing that up. The call center, always use it.
Thank you. So we do have a couple more questions. The first one being, what are the repercussions for claiming something is patented when it is not, or claiming that it is patented when it's only patent pending?
Right, there is a provision for false marking, but it needs to be truly false. Typically, when you say it's patented, when it's patent pending, that there's not going to be any repercussions. But legally, you're not supposed to say it's patented when it isn't. That's false patent. That's false. Well, we can talk, that's under trade. You're also liable outside of the patent area and for false advertising under the trademark or unfair competition. But typically, there is potential liability for claiming something that is patented. When you should say it's patent pending. If it's a mistake, it's not false. But obviously, the whole purpose of this call and this event is to try to avoid situations where people are putting patented when it's only patent pending.
Thank you. So our last question that we have right now is, do these protections only protect IP within the United States? Could someone from another country infringe upon someone's intellectual property?
The answer is yes. We are speaking today only of U.S. protections, but there are protections in other countries for similar to the United States on copyright and on trade secret, on trademarks. And so these protections can be extended through an application process, working with individuals in other countries to have protection elsewhere. And that also, let me just step back, and then during the patent process, there's a certain time period within which you need, an entity needs to decide whether it wants to file for foreign patent protection, so that the worth of a utility patent may be only in the United States, or, for example, it may be in another country where a potential manufacturer may set up a business and start to make your products and sell them elsewhere and undercut your business. So to answer your questions, the ones for today are speaking of the United States, but there are similar protections in other countries. Now, going to the second half of the question, can someone from another infringe upon somebody's IP? The answer is yes. If you have a copyright or a design patent, utility patent, a trademark in the United States, and somebody from another country starts to, within the United States, this is, sell products or perform services that you believe infringe upon those intellectual property rights that you have in the United States, then that is technically or legally actionable within the United States. The country of origin of the infringer does not really matter. Now, however, if, for example, in another country, you have a patent, the entity has a patent on a product, and it's a U.S. patent, people throughout the world are free to practice that patent within their given country, so long as they don't, for example, sell that product or offer that service in the United States, but they can set up business, in any other country and be free of the U.S. patent protection that exists here. And that's the reason why the foreign protection may be appropriate for small businesses in some circumstances. As I said, patent protection is quite expensive within the United States. When it is extended to foreign countries, the expense multiplies. For example, you have to deal with a representative in the other country. There's translations. So the expense becomes a lot more than just getting a patent in the United States.
I have a quick question, John. I read that China has greatly improved on their patenting process within their country. And then I've heard horror stories of the bad practices in China. What have you seen, or have you heard anything about China and whether they've truly improved on protecting people's rights?
Well, I'd say, first of all, the term improvement is relative. So the Chinese intellectual property area was pretty horrific. Basically, it was state-designed intellectual property theft. So when you hear it's improved, the answer is correct. But once again, it is the rule of law in China is nothing like the rule of patent law or intellectual property law in the United States. There have been companies that have successfully asserted their rights in China and have been awarded some protection, but I certainly wouldn't count on it. I mean, it's highly political, and it's basically the subject matter for a whole other webinar, what to do with China. I would caution any company to be very, very careful when dealing with any Chinese manufacturer. If, for example, the small business was a manufacturing company and it wanted to set up some sort of manufacturing arm in China or use a Chinese manufacturer, they ought to tread very, very carefully in that area. There's no guarantee that it's going to be the rule of law is going to be respected.
Okay. Any other questions? So the benefits to patents, obviously, securing provides motivation for useful invention. The more you invent, the more you work on that patent and you dig into it. A lot of times people like saying that they have patents, and it's a big time motivator to do more patents. It facilitates wide knowledge distribution for your product. In a lot of instances, people worry about their product getting out there and getting in the public. But on the other hand, it also gets your product out there and the knowledge of your product into a large distribution. As far as investment from folks and the value of your company, it can induce more investment. And, you know, patents facilitate the derivative of other inventions. So there's a lot of very, very good benefits to doing a patent overall. And then you've got the other thought process, and there's much more to this thought process as a small business. But small businesses can do a provisional patent, work through that provisional patent, kind of develop that product over that year period of time, and they may decide to hold off from doing a patent until they want to partner with a larger company or seek investors and then get the patent. So, you know, you may want a patent later as opposed to running out and getting a patent. You want to be sure to analyze the costs. John's talked about that on and off, that, and we all know that it is very, very costly for small businesses to do patents. I have a lot of good friends that develop product all the time, and they used to always patent their products, and they've gotten to the point where they don't even patent them anymore. They simply develop a product full well knowing that they're just going to keep developing more and more new product, and they've just accepted that the cost doesn't prove worth it. So that's something you have to analyze and think of with your product. And then, will it spur competition through invention? A lot of people say yes, that when you get out there and you get a patent, it spurs your competitors to go out and figure out your product. I have a very, very good friend of mine who developed the first water bottle that filtered water through a carbon filter that was called the Bobble. And he got it out there in Walmart and all across in the retail chains. And he was very, very excited because the CEO from Brita invited him to come to Brita, and had a real lunch meeting with him, and he's all excited thinking that they're going to want to buy his product. And basically they told him, we're copying it, and we want you to know we're copying it, and that if you want to fight us on it, go ahead, but we're going to tie you up in a legal battle forever. So, you know, those kinds of stories, I've heard tons of them like that. So that does happen. And you have to analyze whether it's worth defending that patent or not. He never did defend the patent. As a matter of fact, he let it go because of the tremendous expense. So, you know, it's a thought process that people go through on that. John, did you want to comment on that?
Yeah, I second what you said entirely, and that goes back to the earlier question: is how strong is the protection? The answer is it exists. Whether or not it's respected is another question. In the case of your friend, being just an individual small business, the large company can just ignore it. Now, that also applies, unfortunately, sometimes to government agencies can ignore it. So you just have to be careful. Now, one thing about holding off on a patent and a provisional patent application is that if you have an invention, or what you consider to be an invention, and then you are using it, you're selling it or offering it as a service, you have 1 year within which to file your patent application. You cannot indefinitely hold it off. So if you're going to, you can file the provisional. That's what you should probably do, is just file the provisional and postpone your final decision after you do that. But you simply do not want to just sit on it, because the clock for obtaining it or trying to obtain a patent will begin running once it becomes basically commercialized, using into the public domain. The thought process or policy behind that is that they don't want to have ideas that are freely available in the public domain removed from the public domain. So there is a grace period of that, grace period for you to use it but you have to be careful to use it at your own risk.
I have a question on that, John, that you may be able to answer. What do you term it's been commercialized? If you've built a couple of prototypes and gotten them out for a couple of customers, but not done full-blown marketing and commercialization, does that still count as the time ticking?
Yes, because there's a difference between a commercially successful or efficient product and a product that embodies your invention, so that you can have your invention working as it's intended for its useful purpose. It may be not your full commercial product, but once it embodies and is working as you believed it should work, then it becomes basically public use or commercialized or for sale. So the bottom line is that there is a significant difference between, you know, your whiz-bang commercial product that's in a nice package, or your service that you're providing on your website, and your patentable idea. Once the patentable idea basically is working as you envisioned it, cleaning it up for commercial process does not change the fact that it's already on sale or was used in public.
So I've got a question for you then. Going back to what Laurie said, then if I'm a company that is innovating and inventing fast enough that we decided we're not going to file patents, so we're just moving forward, what's to prevent someone else from coming on close enough within those time constraints whenever we've got the new first inventor to file, for someone else not filing a patent on top of me, on top of my innovation, that could tie me up?
If I understand your question is, for example, you come up with an idea, you put it into commercial use, it's out there in the market. I then said, that's a nifty idea. He didn't get a patent. I'm going to file a patent on it. Is that your question?
Correct.
Yeah. Okay. Though, because yours is already in the market, it's already in the public domain, it would be used as what's the legal term, prior art against my improper patent application. And the patent office, in theory, would reject it, saying, no, you can't have your patent because here's an example of a website, or here's an example of a product available in Walmart, and therefore you can't get your patent because it's already been done. So that the examination process should develop the information which would prevent that person from doing that.
So then we have a question that says, then what is the best way to protect your patent from these larger companies? Whether that was a larger company example or a smaller one, if we are innovating and we've decided we're going to move forward without a patent, what do we do to protect ourselves to where we're not close on the timeline or that we've gone public yet?
So if I understand, is if you have a product which may have a patentable idea in it, but you choose not to patent it. Is that the scenario you're okay? There's other people can copy it because you have no intellectual property to assert against that person. Now you could have trade secrets in some. If suppose it's a new water bottle, as we had the example, and there was a new structure of the charcoal dispersion or something like that. You might have a trade secret on how to form that. Somebody could copy it, but they wouldn't have your innovative charcoal filtering system because that's a trade secret. It's an example where the two types of intellectual property can dovetail with each other. Outside of that example, if you choose not to patent it, then large, small, or anybody else can copy freely. So going back to the actual question is, how do you protect your patent from a larger company? One, you could try to license it. Some large companies, or many companies, do have bring in and purchase companies, obviously, that have innovative ideas. Alternatively, you can try to have enforce it, since it's very expensive, try to find it on a contingency fee basis and have an attorney assist you in that way for asserting your rights against a large company.
Is that typical?
That's pretty much the only way you can. The answer is yes. It happens frequently. It's not, it's not a daily thing, but many small entities do have enforcement through a contingency fee arrangement. Now, it has to be, well, you can get many different arrangements, but as a company, if there is a reasonable product out there and the company is viable, then they probably would have many opportunities to find somebody to represent them on a contingency fee basis against a larger company. Now, if it was, just spurious claim, like for example, there's always a movie that comes out and then there's 4 or 5 people who says, wait a minute, that was my book and that was my story. And, most of those are quite thin claims, shall we say. Similarly with patent type things, you won't find somebody to represent your company if after they analyze it and said, well, yeah, I see what you're saying here, but that's not what your patent says. And you may have a difficult time finding somebody to represent. So it's very fact specific.
Gotcha.
John, have you heard of insurances that small businesses can get to help protect? I had read.
Yes.
And
well, it's more. Go ahead, Laurie. Sorry.
I read about it, and I wasn't sure how viable that was, and does in fact that work? Is that something that you would ever recommend a small business to look into?
I've only had clients on the other side of that type of insurance, where the small business has insurance against claims of infringement. And I'll give you an example. Many small businesses out there don't have a lot of money. They don't have a lot of capital to spend. And if they are attacked or accused of patent infringement, they're looking at hundreds of thousands of dollars of legal fees, which essentially would put them out of business or may put them out of business. And in many cases, there are unscrupulous, in many cases, there are entities, attorneys, or call them enforcement entities, which capitalizes on that financial difficulty and consequently will sue a small business, knowing full well that they can't afford to litigate, and then offer them a settlement at a price much lower than it would cost to defend, even though the small business knows that they don't have any really there's no infringement. They're not liable, should not be liable. And that type of situation happens routinely. Now, there are the insurance that I'm familiar with is insurance against that would pay the infringer, the small entity, for the legal fees or the settlement should they be sued, and consequently they have some safety net protecting them against the, so we'll call it the holdup of a business entity asserting their patent against small people, small entities who they know can't afford to fight. So that's the ones, on the other hand, of insurance to assert your patent. No, I have not encountered that with my clients, but only on the defensive side. And it does work.
Yeah, I had read about 3 different options. One's called Lot Network, one is called RPX, and one is called Unified Patents. And I have not found anybody who has used those. So I would hesitate to recommend anybody to say, insurance is a good way to go and it really works. But it
Unified
may well be worth looking into.
I'm familiar with RPX and Unified Patents in a different context than you're stating that. RPX would be for an enforcement agency or entity where, as the earlier question asked, how do you approach a larger company, or if a larger company is infringing your patent, you may go to RPX and they would assist you. Unified Patents are, if the entity I'm thinking about is a membership organization, wherein the members group together and try to develop defenses, primarily invalidity defenses, against patents that are being asserted against an industry, for example, a wireless industry or some other industry. And that unified patent would then, through the membership, develop a legal strategy and, for example, petition the patent office to have the patent invalidated and thus free the industry from that particular patent. But that's on the defensive side, not an insurance side of those particular companies.
So there's different folks that companies can use for patent assistance. And my bad, I neglected to introduce Jessica Torres, who is your local PRTC. I talked about her on the slide and I meant to introduce her at the very beginning. So my apologies, Jessica.
Okay.
But there are PRTCs, I think in 50 states, Jessica, is that true?
Yeah, so there are actually 84 PTRCs in the US. Our main headquarters is in Alexandria, Virginia. My predecessor that Alan had mentioned earlier, Sarah Butts, she actually now works for them. So she moved to headquarters. We also have a few regional locations. Our closest for Kansas regional location is in Colorado, Denver. But we are the only one in Kansas, and it is actually located at Wichita State University, Oblaw Library. That's where I work, and my office is just kind of like the PTRC, I guess, headquarters for Kansas.
So I can't say enough about what a great job USPTO does, and their website, www.uspto.gov, has just, to me, phenomenal resources. They've got videos, they've got lots of written information. So, you know, if I were to advise a small business that wanted to get an education, I would certainly send them to the USPTO.gov website. And then, as we spoke, there's 4 regional offices. You've got the PRTCs or PTRCs, and then USPTO actually has a pro bono program for small businesses, and I guess those are administered differently, varying from the regions and the different offices that do it. But part of that requirement is that you prove that you need the financial assistance. You prove that you've thought through that patent and have really thought through the best way to patent your product, and that you've actually gone online and done some training. Does that sum it up, Jessica? I mean, I think that they vary a little bit by what you have to do to qualify for pro bono, but that is available to small businesses.
Yes, that's correct. USPTO, they do offer pro bono and pro se programs. Pro bono, you're looking at more free programs, and then pro se is more of a reduced assistance program. And then they also have law school clinic. So it's an opportunity for those people that maybe don't fall within the pro bono or pro se requirements. They can look at the law school clinic, and it would be working with law school students under a patent lawyer, and it's kind of that, it's giving the students training, it's giving the person that's needing assistance help to get their patent through, and then they're also working with a lawyer.
Good. And then, of course, we've got SCORE, and, you know, not all SCORE offices are created equal, but some SCORE offices are lucky enough to have some retired lawyers involved that have expertise in IP. It's always worth asking that question. We've got fine folks such as John, that is your IP lawyer option. And of course, there's consultants. And, you know, there's always the opportunity to partner with a larger corporation, although that you have to be very, very careful when proceeding in that way and have agreements in place, et cetera. But that's some ways that you can get patent assistance.
If I may add, going back to the patent office website, they have tremendous search capabilities. For example, for the ability to look through trademarks. So if a business was trying to think about what they wanted to use as a name, I would highly suggest going and doing a little homework at the patent office trademark site for searching for that. And similarly for patents, they have keyword searching. You can look and see whether or not people are out there for two reasons. Number one, we've talked about getting patents on your product, but you may unintentionally all of a sudden be using somebody else's patent. So it may just do a little homework at the patent trademark office search facilities online may help you tremendously.
Next slide, Alan. So for each of these different areas, there's different registering offices. For trademarks, obviously USPTO with the United States Patent Trademark Office. The copyrights are actually done through the Copyright Office, which is the Library of Congress. Domain names, you know, you've got all those private companies, Google, GoDaddy, domain.com. Business entity registrations are managed by the states. And though, and John, you might be able to answer this question. I've always counseled people that when you register with the state, you also register with DMV. As I don't know that that's required. Is that a requirement, John? I know it is to do government contracting.
No, it's not a requirement. But business entity name and registration are all tied with the trademark and your domain name, because many times your domain name is going to reflect your business name. So all three of those, you ought to be very careful. And as we talked about just a moment ago, searching at the U.S. Patent and Trademark Office website, and then go ahead and register. So the answer is recommended is right.
Okay, I just wanted to clarify. I did not think it was required. I know for government contracting, again, in most instances, when you're doing DIBs, et cetera, you do have to be registered with DMV because they check and make sure that that matches. But anyway, okay, next slide. So just some little tidbits, IP strategies for success. One, keep your employment work separate from your idea. A lot of employers have maybe known or unknown clauses that if you are working on your own product on their dime and on their time, they can stake a claim. And actually, a lot of times in employment contracts, when you join them, you're automatically signing up that if you invent anything, then they can own that. And so just if a lot of inventors need that day-to-day paycheck before they take the leap of launching their own company. And so you just want to double check and research and see what the rules are from your employer. And then two kind of sums up everything we've been talking about. Just really, really important to think through and protect yourself against any others claiming your IP. And number three, if you have people who work at your company, make sure that as they're working on things that could be patented, that you have an agreement in place on who gets the credit and who gets assigned that IP. And if at all possible, have those employees assign that IP to the company so that you don't have an employee that can turn around and stake a claim that that was his. Another thing I think is really important is to really think through your company and make sure to choose a great name. Because I'll tell you, if of all things, a way to brand your company, I mean, I was the executive director of DefenseWERX. When I took over, it was Doolittle. And I got tired of everybody saying I didn't do a lot or I talked to animals. And so instead, I changed the name to DefenseWERX, and now we've got all these works out there, right? And to me, no greater pat on the back of doing a great job of choosing a name when everybody wants to copy it, right? But it's just a great name to brand, and it's inexpensive, right? That's one easy way an inexpensive way for a small business to brand themselves.
And Laurie, if I might add, the 6 topics you have there, these are great topics. Number 1, keep your employment separate from your idea. That's essential. What you said is that depending upon your employment contract with your employer, if you're employed to build certain products or design certain products, and at night you're doing an improved one of those, chances are, even though you're working at home, your employment contract is going to give your employer some rights to that. It's just something you be very careful about. The other idea that you mentioned here, and that is have the contributors assign their rights to the company. We spoke of that earlier about the copyright area, where make sure that it's identified as a work for hire. And in the patent area, you should also have that they agree to assign, and then some of the keywords is, and do hereby assign all their inventions, and consequently that can, in most circumstances, operate as an assignment for the invention should there be a dispute down the road of, you know, the contract or the small business entity ownership. So have contributors assign raises the issue of just having careful contracts, as we mentioned earlier, in the copyright area.
Next slide, Alan. So, and we talked about this earlier, but choose a cost-effective patent strategy, and John mentioned it, and you know, I agree wholeheartedly. Provisional patent is a great way for small businesses to proceed. Consider a global patent strategy. Very expensive, as John said. However, you really should give thought, because, you know, in some instances, what you don't want, perhaps, is somebody from another country just fully taking over your product. Another thing that I have read about often is be cautious with open source software. You know, there's a lot of open source software out there, and a lot of times there's some fine print that if you go on with your software you're developing and use open source software, you have no recourse when all of a sudden your software gets out there and is of public knowledge, and you lose all your IP rights. When you have someone go after your IP, they really, really need to consider the costs. I actually know a gentleman, and I can't even remember. It's been several years since I talked to him and met him, but he actually hired an employee who, or a group of employees who ended up selling his product to a group in China. And they cleared out his business in the middle of the night and took all of his product and took it overseas. He actually had that product registered both in the US and a patent in China. His product, in fact, went to China. He won a ruling that they, in fact, stole his product and assigned a value to it. And he spent years and just millions of dollars. They ruled in his favor. He never collected a penny of it. So just because you get a ruling in your favor and you make that decision to spend all that money doesn't always mean you're going to actually collect or get that back. And in this case, this gentleman never got anything back. And that also bodes to, again, be careful in hiring employees, because, you know, those employees are your trusted employees, and, you know, they're knowing all your trade secrets and your inside company information in some instances. So you just need to be very, very cautious. Anything you want to add to that, John?
No, I don't know what the next slide is, but this might be a good time. Is we've discussed it or mentioned it. Oh, here, some questions several times throughout the session here, and that is the trade secret issue. It's not a formal registration process, but in many instances, it may be one of the better routes for a small business. It has its own requirements. First of all, it has to be a trade secret, as I talked about earlier in the bottle and the charcoal setup example. But then the small business must make efforts to protect it, must identify it, must keep it a secret, must have employees agreements, must make sure that the access to it by visitors as well as employees are on a need-to-know business basis, and treat it as a secret. I'll give you one example. It ties in with, Laurie, your example of an escalator. Well, in the field of elevators, there is a whole library or pool of trade secret information on how to operate them and control them. They're all in the public elevators. You ride them all the time, or used to when buildings are open. But much of that is trade secret protected. You would never give it a thought, but for a small business, in addition to all the IP that we've discussed today that involves, for example, registrations or a process at the USPTO or Copyright Office, trade secrets might be a good idea, but it raises your point, Laurie, be careful who you hire because they can steal it.
So that concludes the slides. I don't know if anybody has any other questions for John and I, or Jessica, actually. I don't think we
see there's two. We don't see their comments. Oh, brief is
Alan, I think
address NDAs.
Sorry. I'm reading it and realizing, sorry about that. Did you, so yeah, it says, Joan, we found the assertion rights help fortify the developer in protection of his IP and is a second argument against larger companies that you sue for copying individual parts of your product. This shows money spent by the developer and is payable to him.
Well, I don't disagree. It's more of a comment than a question, so I tend to agree with the comment. And I see also then there's something about the business of engineering, including relevant employees is part and always part of it. Now, where that is extraordinarily important is in the trade secret area that I talked about. Including relevant employees would be to make sure that they all know what your trade secret is, and that it is a trade secret, and then all that should be written down, because later on when one of those employees defects, goes somewhere else, starts a business, so, oh, I didn't know that was a trade secret. When you pull out the paper and said, here it is, here's the exhibit, that helps you. So including relevant employees is important in many areas. And then I see the next question is address NDAs. I think Laurie mentioned that earlier when she was going to larger companies. One area, well, you briefly address NDAs. Well, NDAs are non-disclosure agreements. I think they're extremely important when discussing ideas with potential customers, or even a large, like your friend with the water bottle and Brita. Depending upon the circumstances, this is where a provisional patent application can come into play, because sometimes in NDA there's a dispute and it's he said, she said, well, what is it disclosed? Well, if the provisional patent application is part of the NDA, and then there's a future dispute about who said what and who took what, that ties it concretely to information that was conveyed to Brita, for example. Sometimes they're not quite as blatant about as copying, and sometimes it's not a patent application, but NDAs can be useful. You just have to use them carefully and structure them. Just like with hiring the employees that Laurie mentioned earlier, who you approach with your idea is also important. Be very careful who you approach. I mean, that's always, be careful of the invention companies that you see on TV. Sometimes they're not all what they advertise to be. I don't know if you have anything else to add to NDAs, but I think they could be very useful. Be careful when you use them and structure them so that you can prove what it is that you disclosed.
Well, and sometimes you'll have people give you an NDA. I've had this experience, and it's a one-sided NDA. So
yes. Well, we always use those for our clients.
Yeah. I mean, so just because somebody gives you an NDA, you've got to make sure that it properly covers both parties. Like I said, I've seen instances where somebody says, yeah, I don't mind signing. I have an NDA. I don't mind signing it. And it basically protects them and doesn't protect you. So you've got to be very careful in those instances. You almost have to
agree wholeheartedly
yourself. So that's kind of a wrap, unless there's any other questions, Alan. You're still muted.
So I think that's all that I see. With that being complete, just a reminder that we will send out the PowerPoint slide and Jessica's one document giving information on the PTRC. Do you want to speak about, Laurie, do you want to mention what we have for next week?
Yes, next week I'm going to have Kira Blackwell join us. Kira manages the NASA iTech program. She's phenomenal. I'm hoping I can get the information over to describe. She's approving it right now as we speak. We've got a lot of exciting things over the next is it 8 Fridays altogether? Now there's 7 Fridays. And what I'm trying to do is give real matter-of-fact experience. Because I spent 30 years as a private sector business myself, and nobody's been kicked in the gut more than I have. So, you learn by doing, right? So I've been out there developing product, running companies, both big and small, and then worked with the government for years. I'm trying to share my real world experience because I think that's what businesses need. Our small businesses today need to know cost-effective resources and the no kidding real facts about running small businesses. So that's what we'll be delivering over the next 7 Fridays from here.
So to that point, I think it's probably ironic and appropriate to bring up the fact that we're not certain what platform we will be using next week. NASA says that they can, according to Laurie, and we've heard information about this for a while now because we've got our Encountering Innovation Conference coming up, and we've had this conversation and had a decision made that we would utilize the Zoom conference program along with a platform that utilizes it for our pitches and for the conference in Encountering Innovation. NASA says they can't use Zoom, so we're going to double check what we can do to make sure we can deliver the training next week. So please be paying attention and don't just assume that your registration click link works. We will do our best to everyone that's registered here that we will get out the proper link, whatever that is. So just a little bit of ambiguity into next week. Mindy, does that sound right? Did I say that?
Yeah.
That makes it. Okay, I think that wraps up what we're doing. Mindy, do you have any instructions? Do we have anything we have to do with the FAST grant, or are we doing the satisfaction survey? I don't know exactly what else we do that they'll get.
Yes, so after this presentation wraps up, we are going to be sending you on Monday. You will be getting a copy of the presentation as well as a webinar assessment, just to kind of let us know how we did and if programs like this are providing any value to you as an attendee. And that session we designed.
Is it appropriate for me to chime in and do 10 Call.
Yeah.
Oh. Kidding.
Yeah, so you'll be getting that on Monday.
Okay.
The presentation and a survey.
Good. Thank you. John, it was a pleasure meeting you and enjoyed your insight and your information. I hope we are able to continue to see you and possibly work with you into the future.
Well, I would welcome it. Thank you very much.
Yeah, I
Thank
really
you.
appreciate it. And thank you, Holland and Knight. I really appreciate it. They're always willing to help. Holland and Knight is an awesome law firm.
Well, you guys did great. Laurie, thank you, and we look forward to next week. Jessica, thanks for joining us, and we look forward to your assistance. So hopefully our folks, after they get that information, if they have any questions, please let us know, and we can direct it to Jessica as well. This will be recorded, so where I know several of our own business advisor tech coaches aren't available because they're already they're already working with other clients. So hopefully you'll be able to get through this, and if this is later, still get the information to us or questions where we can continue working with you. Thank you so much, guys. Make it a great weekend.
Thanks.
Thank you.
Thank you.